You all know by now how much I love the law, but sadly, unfortunately, many people around the world don't actually love us lawyers that much. I guess one of the reasons is that there is a perception that lawyers tend to overcomplicate matters and use sometimes words which don't really make sense to people who are non-lawyers and can sometimes be seen to be overcomplicating the matter, as I said. Today, let's debunk the myth about the words novation and assignment. Two relatively big words that are used sometimes interchangeably, but actually mean very different things. So, novation is a situation where you need to step into the shoes of someone. For example, when the Fairmont Group was taken over by the Accor Group, so Fairmont, Raffles, Swissotel was taken over by the Accor Group, they obviously had a lot of existing management agreements and obligations under these agreements around the world in their hotels, which was taken over by Accor, and potentially that would have to be a novation agreement because Accor then stepped into the shoes of the earlier entities of the Fairmont Group to take over all those rights and obligations. In contrast, for example, in terms of assignment, the Harrods brand, which I'm sure you all are very familiar with and have often shopped at Harrods in London, was taken over by the Qatar government at some point many years ago. Now, obviously, with that portfolio came the Harrods trademarks. Now, in order for the Qatar government to take the benefit of those trademarks, that would have typically been an assignment of the trademarks. So they were not sitting in the shoes of the earlier owner of the brand, but they were actually acquiring the brand by way of assignment. Now, I think I simplified that too much, so let's get a little bit more complicated around this. You often see things like assignment in terms of insurance beneficiaries. So, for example, I might be paying your insurance policy, but I could assign the proceeds of that insurance policy to you. So that would be an assignment as well. So hopefully these are just a few examples that debunks the myth about the complexity of novation and assignment. You need to be careful when you're using these words, and you need to be careful when you're doing them, because obviously if I am an owner of, say, a Fairmont hotel, I don't want my contract to be novated despite the sale to a big group, to a group that might be lesser than the group I already had within the brand I was already operating under. So we often negotiate a good, robust novation or assignment clauses to make sure that assignments can either be done if they're approved, assignments must be done by way of everybody's agreement, of course, and the same for novation. But we sometimes want to protect against ending up in a situation where you have an agreement with a party that isn't a party that would match your expectations. So that's the only word of caution, but I hope you learn to love the law as much as I do by the end of my many videos. So happy watching, and thank you for watching.